We are live. Good evening, everyone who's watching us right now. And so we appreciate you. We come in live from YouTube for those who might actually be having access to this from podcast. We appreciate you. We see that notifications are coming in. Apologies, but as I mentioned, evening today, we are at the courtroom literacy, where we discuss issues that has to do with legal and tax implications, and in the main, what you who are creating wealth in business community you shouldn't be doing or you should be doing, because in most cases also it's about what you should be doing and what you should be learning and leveraging through legal and tax implications. I'm with my attorneys here, Lisa and Bruce. My name is Shilly Boy, and then I'll let them briefly introduce themselves and we get into the discussions of the courtroom of today.
Evening, everybody. I'm Bruce Andre Barkhuizen from Bruno Smau Attorneys. I'm a litigation, commercial, and property attorney, as well as a notary. Have extensive experience in commercial wills, estates, trusts, and commercial matters. I'm very amped about this evening. It sounds like we've got a very interesting matter actually to dissect. So I'll hand the floor over to Lisa.
Good evening, everyone. I'm Lisa Hugo. I'm a candidate attorney at Intergen. We specialize in estate planning, wills, trust, and tax advisory services. Once again, I'm very pleased to be joining you all, and I hope you take a lot away from the case that we're going to be dealing with today.
Thank you so much, guys. Do you want to, Lisa, maybe tell us what's going on? Because I briefly read on this case, and I can tell the viewers and the listeners that, you know what, it's quite a very interesting, it's commonly related to most of our clientele who typically become property investors, to say. And it got me thinking, I don't know if you saw, I sent you a voice note, Lisa, about please follow up on those transactions, because it got me worried to say, what if those clearance certificates were not obtained legally so, and it's quite interesting. Someone might be under, what is Shilipo all about? All of a sudden you're talking about clearance certificate. So I'm gonna allow Lisa to do justice and actually give us a brief background on what is the case for today.
Okay, so there were 4 individuals. So in legal terms, they'd be the applicants, but to keep it simple, we're just going to call them the purchasers. They were purchasing a property in the name of a trust from the seller, who is respondent number 1, but once again, we're just going to be, for purposes of simplicity, refer to them as seller, and then obviously respondent number 2, which is the municipality that is involved in this case. So the purchasers approached the seller, they purchased this property, and one of the requirements was, in order to have the rates account transferred into the hands of the purchaser, they had to ensure that they got the clearance certificate from the municipality. So they received the clearance certificate, and then all of a sudden, the municipality said, no, this is a fraudulent clearance certificate. We didn't issue this. So now came the issue of, okay, well, now they can't have this rates account transferred. The municipality then shut off all the electricity and the water, so basically all the utilities to the property that they just purchased. They went about the transaction to the T. They fulfilled their end of the entire transaction, but now they're sitting without these utilities, and they followed the correct procedures. So obviously they would now approach the seller and say, what went wrong? Because you were supposed to furnish us with this clearance certificate so that we could now occupy this property in peace, as it is their right to do so. So the issue came up between the seller and the municipality, because there was a massive amount of outstanding rates and taxes between the seller and the municipality. And so this is when the court really stepped back and said, who is the matter actually between? Is the purchaser even truly involved in the actual matter at hand? And this is when they realized that the purchaser is actually just being prejudiced, and that's why they obviously approached the courts, when in truth, the actual legal dispute is between the seller and the municipality. Essentially, so going, like, just to sort of wrap up the facts of the matter, so then the courts were like, okay, so what is the actual issue here? the seller had not paid up to date, has not settled the account with the municipality, and the municipality was then taking it out on the purchaser by refusing to transfer it into their name, and thus depriving them of the full use and enjoyment as per their rights when purchasing the property.
Bruce, let me bring you here. Maybe let me. And what I love about this, I'm not a lawyer. I'm just a chartered accountant who loves law. So now, let me bring the conversation in the sense that here's a property that was transferred legally from the deeds office point of view. We're not gonna even discuss. Actually, we should even discuss how that came about, because now the contestation here is that the clearance certificates of the municipalities claiming that the clearance certificate that are required as part of the conveyancing processes to actually transfer the property is claiming that they were fraudulently being obtained. And I feel, as a property investor, imagine now you're sitting on a property that you can rent it out and you don't have deep pockets of fighting this case in the court. Your electricity and water has been suspended. The banks now say, listen, Shilibo, we want money every month because you have to pay the bond. Would you agree with me? Because everything has been passed. And the seller got the money, is not cooperative. I mean, from you, from legal speaking in a layman, what really went wrong?
Well, to get right down to the point, is somebody got a dodgy clearance certificate. Now, I read the case and the court feels that maybe the seller spoke to a friend and a dodgy clearance certificate was issued. So that's actually where the issue lies. However, the court came to the rescue of the person and said, nope, Mr. Seller, it's Mr. Seller's problem, it stays Mr. Seller. Sorry, municipality, you're going to have to open the municipal account. The purchaser had no idea about it. So this is what's actually important here, is that if you're able to show that you took diligent steps to try and find out, I doubt that the court would try and penalize you. In fact, the court would possibly praise you, as we've seen with other cases. Also, here they were what was called a bona fide purchaser. In other words, they bought it in good faith and they had no idea about the previous wheeling and dealings of the seller. And also something else that went wrong was that there was no formal dispute regarding the rates and taxes account in respect of the seller's account. So in essence, that was never being contested. There was no real record of it being contested.
But tell me something about, I mean, I'll allow Lisa also to just jump in here. The issue of clearance certificate, from practical point of view, as part of the due diligence as a property buyer, would you say, and it got me thinking, I was like, during the steps of me doing a due diligence when I'm buying property, is there a way for me to verify such issues? Because to me, that's a lesson that I'll want to put this as a part of the checklist in my due diligence checklist to say, maybe as part of obtaining the statement from the municipality, what I propose is just to also, because normally you'll get the statement of account from the estate agents. And most of us, we never really go to the municipality and verify if that statement of municipality is legit. So it might be that before you even put an OTP or offer to purchase, you take that statement and you make a call and say, or you go to the municipality, because now you'll be serious about this deal, you want to go ahead with it. Or in fact, even to save your time, you might say, upon receipt of, or upon acceptance of my offer to purchase, I want to do a due diligence, and one of them is verifying the outstanding balances and everything with the municipalities. Then you then go to municipality as part of your due diligence to say, listen, here's the statement. I just want to confirm the outstanding balance, because to me, it's in your best interest that you don't want to find yourself then later on get caught up in these issues. Yes, as much as I agree with you, Bruce, the courts might be in your favor as a result of you being a bona fide seller, but they might actually not what do you call, the banks might actually not actually entertain, or they might entertain it and you find that it's taking longer, and at that time you're bleeding from cash flow point of view. So my thing will be just to include that as part of the due diligence. Bruce, you wanted to say something?
100%, you can include it as part of the due diligence. That being said, there's an issue right there, and that with POPI having come into effect, the municipality will say, sorry, you're not the owner of the property. So you'd actually have to get a letter of authority from the seller saying you can go and speak to the municipality. So it's not as simple as it used to be, unfortunately. You got to take an extra step in order to verify it.
But before I even actually allow Lisa, when you're mentioning that you can actually obtain the letter from the seller, if the seller agrees to give you a letter, that can be a bit of assurance that there's nothing they're hiding. Think about it. If they're selling this property, wanted to get away with, if they're selling this property, wanted to actually run away from this issue, running away from this issue of disputes with the municipality, they wouldn't be allowing you to go and verify with the municipality. Would you agree with me? So
100%.
Yeah, but that will stop you to further go and actually investigate, because the seller also might not actually be aware that they are in disputes or there's a potential disputes with the municipality.
100%, 100%. And as some of our clients have found out, often disputed rates and taxes do not appear on the statement from the municipality.
Sure.
Right? They put it in a separate account, if that makes any sort of sense. So again, you're 100% correct. It must be a blanket letter of authority saying purchasers got every right to go to municipality at all municipalities and inquire about all accounts relating to that property.
So when you're saying, Lisa, you'll come in after this. When you're saying that the account is separated, the one is under dispute is separated, how would you then go about obtaining such kind of information? Well,
the accounts are all still linked to the property. The property is key here, right? And also the seller's identity is key. So you can go to the municipality and say, hey, here, I've got this letter. I want you to tell me all the accounts that the seller's got and relates to this property. So if there's a second account, it'll be revealed. I know that I'm not going to mention which municipality, but a certain municipality in Gauteng did at one stage separate disputed amounts and undisputed amounts into two separate accounts. And in fact, they would give the lessee an account of their own. So there could be a potential multitude of accounts in relation to one property. It was bananas. I must be honest with you, and sorting it out was a bit of a mission. But anyway, see their police is getting bored stuff.
Lisa, you wanted to jump in, and we have been really sidelining you. Come again.
I honestly think that it's actually a very common oversight for a purchaser to focus on fulfilling their end of the bargain. And obviously going into any transaction, you expect the other party to be a bona fide party. You're not expecting them to cut that many corners, because initially when you see a bargain, your first instinct is to hop on it as quickly as possible. You do the bare minimum due diligence, make sure this person isn't completely shady, make sure that you're getting value for your money. So you sort of do just the basics, just good enough. Look at the property that is not collapsing, etc. Whereas these are a little bit more intricate moving parts that happen. And to think that someone would fraudulently, although it is more common than we think, have this clearance certificate drafted, especially because in this specific case, it was actually an employee at the municipality, but she had resigned a few years ago. So then you really see how sneaky people can be, because if you were to very quickly just verify, had this person worked at the municipality, the quick answer would be yes. So you wouldn't be that suspicious. But then when you actually have to sit and look into it, that's when you realize that the third party, being in the municipality, had that duty to, for one, see, okay, no, but fraud actually took place. Why have they not taken any action against this fraudulent act? They just let it slide and then wanted to take it out against the purchaser, as well as why had they not sort of looked into these outstanding rates and taxes? They didn't take any steps towards having that account paid in full. And then to wait until the last minute when now the property has already been transferred to be like, oh no, but we're not going to do any of the opening of accounts because this property, the previous seller owes us this much money. So it's an unfortunate, there's only so much you can do. Like we said, you can approach the municipality and try to get this information, but at the end of the day, you can only take that much precaution. There will always be certain aspects that are out of your control or you cannot necessarily predict.
100%.
Speaking of certain situations that might always be outside of your control, don't you think the notion or the position that I always want to hold or take is always using my own conveyancer as a purchaser, especially if I'm a returning property investor? And I'll tell you why. Because then you know that your conveyancer uses credible agents to obtain clearance certificates. You can, I mean, if I always use a BSA law for my property transfers, and I push the sellers to always use I know sometimes you don't get it your way, but wouldn't that also help in minimizing these potential issues?
I feel like, Bruce.
Sorry, Lisa.
No, come, Lisa. Go ahead, Lisa.
I feel like it could, but once again, the seller gets to opt for which conveyancer they would like to use. And like you said, the comfortability you have as a purchaser using your conveyancer, the seller might argue the same point. They trust their conveyancers because they want to get paid at the end of the day as well. So they might feel like, no, but this is my property. I want to sell it. I want to use my conveyancer. So you will most likely have a clash and that pushback between the seller and the purchaser, because each person wants to be in a beneficial position where they feel most comfortable and they feel the most protected during that transaction. So that could prolong the process. And like people said, time is of the essence. So you might not have the time to just sit back and negotiate back and forth whose conveyances you're going to be using the entire time. And even so, if your conveyancer doesn't do as much due diligence as you would like, because like I said, at face value, this was an individual that worked at the municipality, and they might have been familiar with that very individual because they'd been doing those transactions with that municipality previously. So maybe they were not aware of this person now resigning. So unfortunately, it does take a lot more involvement and a lot more research and precaution, which, like I said, it's often an oversight.
Time is of essence. I'm seeing that we are close to closing. Bruce, you wanted to come into party.
As much as I would love to raise the banner and keep the banner of BSA, actually, Lisa's absolutely right. Right? Is choosing a particular conveyancer might or might not have the desired effect, because in this particular matter, the certificate was applied by the seller. So hypothetically, this could happen again with, for instance, a rates agent or a rates consultant doing exactly the same thing, being under pressure, deciding, you know what, let me forge something because I cannot get this done. The municipality is offline for decontamination or is offline for end of year party. Oh, did I say party? I meant for end of year finances.
You love parties, you just give it away. Okay, yeah.
But the short of it is that just at least gain that letter of authority, at least put the specter of the inevitable in the mind of the seller. And that's not necessarily a bad thing, right? Ideally, you do want there to be a little bit of tension in the agreement. That's a good agreement. It means that not everybody's getting what they want. Each party is checking each other out. So there's checks and balances. It might feel uncomfortable, but it actually optimizes, increases the the need not to trust each other, actually.
Yes, like a scare tactic.
Well,
Kind of.
yes and no, but for instance, rope grip clauses, right? I, as the seller, feel at ease. I, as the purchaser, feel on edge. However, there could also be a clause in the agreement that says that I must give vacant occupation. I, as the seller, am on edge because now I've got to give vacant occupation. I've got to evict the illegal occupants. So again, these sorts of tensions actually work together to create an ideal situation. But
I like that. Tension is not a bad thing after all. Like I always say, when you're saying to the seller, I want vacant occupation, otherwise I'm not releasing the proceeds from the disposal, that also can make them to cooperate with you, which I always enjoy and like. I think from this is to ensure that you strengthen your OTP, even if as much as they're going to use their own conveyancing, you might want to consider having to use and upgrade your OTP, as you always say. I'm sure I'm coming back, Bruce. I'm going to make sure that in that OTP, I'm also adding that clause where it says that if there's any disputes with municipality, is in the account of the seller and I can come after them. So whichever way you drafted, Lisa, I want to make sure that that OTP is upgraded. So I think that's what I'm taking from this to say. There's an additional clause that needs to go into the OTP to protect yourself as the purchaser, as a property investor. And also you need to further do your own due diligence as much as the agreement that you don't want to find yourself having to spend a lot of time at the courts. You want to spend time making money, as Lisa said. Time is of essence. So the reality is that to avoid wasting time, rather do things from the onset properly, and includes having conversation with the municipalities. And I think it goes back to making sure that you also affect your business model by focusing so that you know the municipalities that you're dealing with and you understand the area. Then you'll know the problematic properties, opportunities, and then at the end of the day, that could also minimize your business risk to a certain extent. Some might argue, say, the higher the risk, the higher the return. Now that's another debate for another day. Lisa, you're closing. Bruce, you're closing.
Bruce, would you like to go first?
Ladies first, by all means.
Okay, once again, I'd just like to thank you guys for joining us. I hope you took away a lot from this session. As a property investor, it is always in your best interest to educate yourself, read up on different cases. Not only are they interesting, but you'll also learn so much, and you might not make the same mistakes that other property investors made before you. And yes, thank you so much for joining us.
Thank you all for joining us. What I've taken away from this case is that doing a little bit of due diligence is often worth more than the money and time you put into doing that due diligence. Often it can save you an enormous amount of money.
Thank you so much, Bruce. Thank you so much, Lisa. We'll meet again on the second, second Tuesday of the month. Am I correct to say that? Yes. Second Tuesday of the month, we come live. We might actually add additional one. We just need to verify the timetables, and then it might be twice a month. We just need to finalize that. But thank you so much, and share as much as possible. And again, like I say, for me, parting shot is also that due diligence, and make sure that you've got a due diligence checklist. It's growing on a daily basis. As Lisa said, read as much as possible around your subject matter. In this case, is the issue of property investing. So you need to read as much as possible. And then from there, upgrade and update your checklist so that you are always up to date. With that, thank